हाँ. Okay. Okay. Bye. Very good morning, all. Today we are having last session on 50 important questions that we have been discussing in a series since 3 sessions. Today we will be concluding these 50 set of questions with the last 10 questions that we have, and we'll also try to help you out with some last minute tips for SEBI legal exam, which can help you in some way and boost your confidence, lower your nervousness levels. Okay, so let's start quickly with the first question that we have in today's set. This question is from direct section based question that we have. Section 82 of IPC provides that nothing is an offence which is done by a child under. The options are 6 years of age, 7 years of age, 9 years of age, 10 years of age, and 16 years of age. Okay, so section 82 of IPC talks about an exception that is provided, a general exception. So it is a general exception that is providing protection to an offense committed by a child. But what is the age limit for that child has been provided in these options. And let's have a look at the correct answer. That is B, a child under 7 years of age. Section 82 protects the act of a child under 7 years of age, and that is covered as a general exception under IPC. Okay. Let's go to the next question. This is from Evidence Act. Definition of secondary evidence has been given under dash of the Indian Evidence Act 1872. Now I have picked here some section based questions also. We cannot predict that we won't be asked section numbers at all or section based questions, because there are some very important areas from which sections are expected. Like secondary evidence is a very important part. Primary evidence of Evidence Act, secondary evidence. So for these we need to be well versed with the sections. So that's why I have picked these kind of questions also today for discussion. Options are section 61, 62, 63, 64, 60. Now to make it more confusing, the options are given as like very near about, so that the answers seem to be more confusing for us to solve. And the answer is section 63, that is C option. Section 63 describes secondary evidence. Secondary evidence means and includes what? Certified copies that are given under the provisions that are hereinafter contained, copies that are made from the original by a mechanical process which in themselves ensure the accuracy of the copy, and copies that are compared with such copies. Then the copies that are made from or compared with the original ones. Then the counterparts of documents as against the parties who did not execute them. And also the oral accounts of the contents of a document that are given by some person who has himself seen it. even that oral account is also considered as a secondary evidence. So we have to be very clear with these concepts. What are these concepts? What is primary evidence? What is secondary evidence? You don't have to get confused. These are very basic concepts and questionable areas. Let's go to the next question. Question number 3. This is from constitutional law. Which of the following writs is issued by the court in case of illegal detention of a person? Now, writs are also the 5 writs. You should know everything in and out about this. Is very, very, very basic question. So options can be given, twisted questions can be given on such easy concepts also. What are writs? Which writ is issued when? And when it is not issued specifically. Now this question is talking about in case of illegal detention of a person. So the options are quo warranto, habeas corpus, mandamus, certiorari, none of the above. Now this is actually very easy question. Answer is of course habeas corpus, which literally means have the body. By this writ, the court can direct to have the body of the person who is detained to be brought before it in order to ascertain whether the detention is legal or illegal. So such kind of questions which are actually very basic and direct, easy questions also come. The level of questions is of course between easy, moderate and difficult. So easy questions can also be put forth and they can also be slightly twisted. Be prepared for all such kind of questions. Okay, question number 4. A contracts with a cricket team to play for World Cup and A falls ill and is advised by the doctor to rest. So this contract, what will the consequences of this contract be? This is from contract law, situation based question. Here you need to apply the basic principles and doctrines that you have studied relating to contract law. You need to apply your logic and those principles here, and then you should answer such kind of questions. Don't be in a hurry while you are solving questions. Don't forget that you have negative marking also. The options are: the contract is still valid, contract is void ab initio, the contract becomes void, contract is voidable at A's option, or the contract is frustrated. So out of all these options, please suggest me which is the most correct answer. If A falls ill and is advised by the doctor to take rest, so he will not be able to play for the World Cup. So what will be the consequences? What will be the consequences of the contract? Yes, you all are right. The contract will become frustrated. Doctrine of frustration of contract. That is, the answer is E. A frustrated contract is a contract that subsequent to its formation and without fault of either party is incapable of being performed due to an unforeseen event or events that are resulting in the obligations under the contract being radically different from those that are contemplated by the parties to the contract. So the contract will be frustrated. Be very clear with these basic terms. What is valid, what is void ab initio, what is voidable, what is frustration of contract. Don't get confused. Next question. Which of the following interests is not protected by the law of tort? Now we are going to tort law. We can have questions from consumer, from tort also, though we have only 5% weightage for both the topics, but these questions can help us score marks in the exam. So don't leave such topics. Options: loss of commercial profit due to competition, reputation, physical safety, peaceful enjoyment of one's land, all of the above. So which of the following interests are not protected by the law of tort? You need to find out. You need to answer. This is a very, very basic question. If you're aware of the remedies that are provided under law of tort, then you can very easily answer this question. So anybody just quickly answer what can be the correct answer for this question. Yes. Answer is A only. That is loss of commercial profit due to competition, because all the rest options you can deny over here, because all these are protected by various remedies provided under the law of tort. Only answer that is left is A, which is not any particular violation of interests under law of tort. Commercial profit and due to competition is actually not a tort. It is actually, everybody has their own right to earn their profits and have a healthy competition. Nobody can be stopped from doing any particular business and earning profits, even if they are a competition to you. Next question. If a company which is formed with unlimited liability wants to convert to a limited liability, then it should pass what? Company law, very important area. A question from this area cannot be left out. So, if a company which is formed with unlimited liability wants to convert to a limited liability, then what shall be done? Options are: an ordinary resolution shall be passed, a special resolution shall be passed, there is no need to do anything. Either ordinary resolution or special resolution can be passed, or both ordinary and special resolutions can be passed. Quickly, anybody just answer. What can be the answer? What is done in such kind of a situation when you have to convert an unlimited liability to a limited liability? Then what resolution can be passed? Yes, you all are correct. Special resolution for effecting the conversion of an unlimited liability company with or without share capital into a limited liability company by shares or guarantee. Such a company shall pass a special resolution in a general meeting. Such a resolution can be passed in a general meeting, and that is a special resolution. Okay. So, quickly going on to the next question that we have in today's set. Question number 7, that is regarding the percentage of shares that should be held by a company in another company so as to become subsidiary. So any company, answer has also been displayed on the screen. That is, any subsidiary company is a company that belongs to another company, which is usually referred to as the parent company or the holding company, and the parent holds a controlling interest in the subsidiary company. So it has or controls more than half of its stock. More than half, that is more than 50% of the shares should be held by a company in another company so as to become its subsidiary company. Very easy concept, but these kind of concepts are questionable, like subsidiary company, parent company, what these companies, how they become a subsidiary company. So they become a subsidiary company by having more than 50% of the shares with them. Okay. So let's go on with the next question that we have. Question number 8. The capital, again from corporate law, company law, very important. The capital clause of a company can be changed with the permission of. First of all, you should know whether the capital clause of a company can be changed or not. And if at all it can be changed, then how it can be changed? What is the procedure? Here they are specifically asking with the permission of whom, but you need to be aware of this area as well. The options are with the permission of the company law board, with the permission of registrar, with the permission of National Company Law Tribunal, with the permission of court, or none of the above. So, the capital clause of a company can be changed with the permission of whom? Quick answers. Today's we have all set of easy questions with us. We are going to end the set of questions on an easy note because we have questions easy, moderate, difficult. So the answer is D. That is quote. All clauses of memorandum except capital clause can be altered by following the provisions of section 13 of the Companies Act 2013 by passing a special resolution. Thus, it can only be changed by the order of the court. Okay, we well versed with such kind of provisions. Okay. Next question. Question number 9. The chairman and other members shall have the right to relinquish office at any time before the expiry of their tenure by giving a notice of dash in writing to the central government. So what are they asking here again from company law? The chairman and other members shall have the right to relinquish their office at any time before the expiry of their tenure by giving a notice of what? The notice of what in writing to the central government? Options are how much time in prior shall be given to in writing to the central government. Again, a procedural question. So the answers are, options are 2 months, 3 months, 4 months, 5 months and 6 months. Answers are, of course, it is 3 months, as you all have guessed right, as provided under section 5 clause 2 of the SEBI Act 1990. So the board may take measures to undertake inspection of any book or register or other documents or record of which category of companies they have basically asked. Quickly, somebody answer. What category of companies are covered? All public companies, or only the listed ones, or only the unlisted ones, or all listed public and public companies which intend to get listed, or all of the above? The answer is D. Many of them have guessed them right, as provided under section 11 clause 2 subclause M of the SEBI Act 1992 correctly and directly mentions that all the listed public companies and the public companies which intend to get listed, they are the board may take measures to undertake the inspection of the book, register or other document or record of this category of companies. Okay, so here we end our 50 important set of questions that we are having continuously discussing these set of questions in 3 to 4 live sessions that we have had on this topic. The purpose of discussing these questions was not that these questions will come as it is word to word. Of course, that is not possible. The questions that are asked in competitive exams are actually very innovative ones. But the way the questions are asked, the level of questions is easy, sometimes moderate, sometimes difficult. So the purpose behind taking these sessions is basically to help you all revise the content, make you all practice more, be prepared from the areas which are more probable of being questioned in exam, so that you take care of minute details that can be asked in the exam and not leave anything which is very important, and be prepared mentally as well for the exam. And today I would like to, before I end this session, I would like to give you all some short tips also relating to this exam that you have in another 17 days. So you can just prepare yourself for last 15 days that you have in your hand. But you can clear the exam if you utilize it well. Okay, utilize your time well, utilize your time smartly, so that you all don't face any kind of problems while you do not lose confidence, because very important is your confidence. Okay, so some tips that I would like to give you all is last minute tips. First of all, start revising all the content that you have with you up till now. It's time to go on the revision part. Whatever done is done, but start revising the content as much as you can. Start covering the important areas first, and don't indulge yourself more into much of new content now. This is not the time to get confused. Don't add subjects and areas which are actually totally untouched for you. Don't go into those subjects now. Don't confuse yourself. First, be confident and very sure about the things that you have read already. You must have, of course, highlighted the important areas also up till now. So start focusing on those areas. Start revising the content more often. Then thirdly, I would like to suggest, on it's last minute, but practicing mock tests as much as you can do. That should be done always. You whenever you find time, just solve questions so that you get more variety of questions before your eyes. You get to witness more and more questions, more and more points come into your mind. But one thing I would like to caution you here is that you should not lose your confidence while you are solving mock tests, because what happens is maximum time people start solving mock tests and they imagine it like you are 100% prepared and now you should know everything in the mock test. If you are not able to solve the questions well, that means similarly in the final exam also you will be losing marks, because you are losing marks in the mock tests, and because of that you lose your confidence. This should not happen, especially at this time when you have only 15 days in your hand. Solve mock tests, but change your mentality that it is your final paper. Solve mock tests with the motto of getting more and more questions and more revision by solving mock tests. That should be your object. Be positive, okay? Because you all think that we are not prepared well up till now, up till last minute, and then you lose your confidence. That should not happen. Be confident, practice more and more mock tests whenever you get time in the day, and mark those questions then and there. Suppose when you are checking the mock test and you get to know that this area was something where you went wrong, so mark that particular areas where you went wrong, so that when you are sitting for final studies for your exam, you again can go back to that area and revise whatever mistakes that you had committed, so that you make sure you do not commit those mistakes again in the exam. So the motto of mock tests is ultimately, again, it has to be revising your content well. Okay. And next thing that is important here is negative marking. As I have observed in the live sessions as well, the live lectures as well, and then I have always seen that many people are actually tensed about negative marking. Negative marking makes you all lose confidence, but that should not happen. While you are solving questions, make sure that you avoid complete guesswork in the exam. I'm talking about when you go for the exam, okay? Do not first solve the questions you are very confident about, which you are very, very well prepared, and then solve the questions which you think that you know to some extent. Because it is not like you cannot leave everything. कहीं ना कहीं तो आपको थोड़ा गेस वर्क भी करना ही पड़ेगा. एक्सेप्ट दिस फैक्ट, कंप्लीटली आपको 100% पेपर आता होगा ऐसा कभी नहीं हो सकता. ओके, सो आपको थोड़ा तो गेस वर्क कभी ना कभी करना ही पड़ेगा. सो टू सम एक्सटेंट यू हैव टू टेक रिस्क, बट रिमेंबर, complete 100% risk you cannot afford also. So you have to somewhere maintain a balance between taking risk but to some extent, and being confident, and avoiding complete guesswork, because 1/4 mark will be cut in case one question goes wrong, and one question carries 2 marks. So like that, if 8 questions are wrong, then you will lose one question mark equivalent to one correct question. Okay, so try to maintain a balance and be confident about what you are knowing and solve that first, so that you are actually knowing where you stand and you can solve rest of the questions according to that strategy while you are solving the paper. And another tip that I would like to give you is that phase 1 पे फोकस करो. एग्रीगेट कट ऑफ 40% है. 40% अगर आपने लाया तो ही आप फेज 2 पे जा पाओगे. सो अभी फेज 2 के बारे में सोचना भी नहीं है. जस्ट फोकस ऑन फेज 1, बिकॉज कट थ्रोट कॉम्पिटिशन है. यू हैव ओनली 34 वैकेंसीज. सो अगर आप फेज 1 ही क्वालिफाई नहीं करते हो, सो हाउ विल यू रीच फेज 2? तो फेज 2 के बारे में तो अभी सोचना भी नहीं है, देखना भी नहीं है उस तरफ. जस्ट थिंक अबाउट द aggregate cutoff that you have to achieve is 40%, and how you are going to achieve it. Now, one more thing I would like to caution you here is, don't aim on just achieving 40%. Aim for more, so that at least you get 40% in the aggregate. Aim for at least 60%, at least, so that you achieve 40%. Now, on a rough calculation, out of 50, if you calculate 40% of 50 questions, then approximately 20 questions should be correct for you. Okay, so plan your studies accordingly. Be well prepared, well revised. Don't get confused with new areas now. Even if you have left something which is totally untouched, leave that now. First cover the high weighted subjects that I would like to suggest: company law, securities law, contract law, constitution. All these together comprise almost 50% of the weightage in the SEBI legal syllabus. Company law 15%, securities law 15%, altogether 30%. Contract law, constitution, at least 50% of the syllabus is from these subjects. So cover these subjects well first, and then after you have covered at least 50% of your syllabus in these 15 days, first do that, and then after you are done with these subjects, then go to the other areas which carry and cover those areas. Okay, so that at least you are done with the aggregate cutoff part in these subjects only, so that you get more time to cover other areas also. Cover leftover subjects, and that should be as per your convenience. If you know कि हाँ मुझे टॉट्स बहुत अच्छे से आता है, तो उसको आपको ज़्यादा टाइम देने की ज़रूरत नहीं है. लेकिन अगर आर्बिट्रेशन है जो आपको लग रहा है कि आपको पढ़ने की ज़रूरत है ज़्यादा, एंड यू हैव 5% वेटेज फॉर बोथ, सो आप उस हिसाब से, आपके कन्वीनियंस के हिसाब से आपकी स्टडी प्लान करो एंड यूटिलाइज योर टाइम वेल. इंपॉर्टेंट एरियाज पहले कवर करो and don't indulge into new things now. एक आधे कोई क्वेश्चन के लिए जो न्यू एरिया में से आएगा उसके लिए आप बाकी के इम्पोर्टेंट एरियाज का टाइम वेस्ट मत करो अभी. एंड अगेन, बी काम, डू स्मार्ट वर्क, बी कॉन्फिडेंट, बी रिलैक्स्ड. You can be the one among